Hello, everybody. Hello. Turn this down a little bit. Okay. Hi, everyone. Happy Thursday. Coming to you live from Demopolis, Alabama. Say hello when you come on. Let me turn this off so we don't get interrupted. Hello, Facebook and YouTube. Hi, everybody. This is Attorney Abisola Olaleye Samuel, immigration lawyer based in Alabama, representing immigration clients in all 50 states. If you have an immigration case that my firm handles, we can and do represent immigration clients regardless of the state you live in. So don't let that be a deterrent to you getting the attorney that you want for your case, because they don't live in, they're not practicing in the state. Immigration is federal practice, so any immigration lawyer in any state is able to represent you no matter where you live. So if you need to contact our office here, number here is 334-341-4475. You can also send an email to aos@olaleyelawfirm.com. You can also visit the website. Website is right there on the screen, olaleyelawfirm.com. I do vlogs, and a lot of information about immigration that will be very helpful to you as you navigate this immigration process that I have personally been through, so I know firsthand what it feels like. But anyway, come on in, say hello when you come on. Let me know you're here. I want to talk to you today. All righty, yes, Shigoni. I want to talk to you today about I-751 and what you need to know. I-751, what you need to know, kind of like a guide towards filing your I-751 and making sure that you do it right, and making sure that you cross all your T's and dot all your I's. That's what we're going to talk about this afternoon. If you have a question, put it in the comment section. If you want to set up a consultation with us, you can always call our office or send a text to this number that I said earlier, which is 334-341-4475. So I-751 is the petition that you have to file if you are a conditional resident, meaning you were given a 2-year green card because your marriage to your spouse was less than 2 years at the time you were granted that status. So if that happens, you would have that 2-year green card and you'll be required to file I-751 in order for you to get your 10-year green card after those 2 years. And basically it's more or less like you're having a second interview the second time around. So even though you've had your interview first before you were granted your conditional residency, when you file I-751, you are required to file jointly with your spouse. And the same evidence you used in the beginning to get your 2-year green card is also part of what will be you were interviewed upon. So your information has to still be the same. And immigration expects that within that last 2 years, you have additional evidence of good faith marriage. So that's a general requirement. One of the tips I want to give you upfront is this. Be sure to use an updated version of the form. On USCIS.gov website, before you file any application or petition with USCIS, I always recommend go on their website, uscis.gov, and make sure that whatever form you want to file, you look for the most recent edition of that form. If you use an outdated form, USCIS will reject your application. Another tip is make sure you include the correct filing fee. So right now, I believe the filing fee for the I-751, don't quote me on that, I think it's $5.95. You're also required to pay for the biometrics fee. So those are two important things in order for you to avoid your form or your application being rejected. Tip number 3 is this. Be sure you complete every section of the form that applies to you and your spouse if you're filing jointly because if you omit information that's important or necessary, that's another ground that USCIS can deny your petition. So those are, the initial housekeeping rules to think about. Now, you are able to file the 751 within the 90 days prior to the second anniversary of your conditional residency status. And that's a mouthful. So basically, before within the 90 days that you have, within the 90 days before the second year anniversary, since you became a conditional resident, you can file the 751 with your spouse. If you're filing jointly with your spouse, you cannot file earlier than the 90 days period. And you also should not file later after the expiration of your conditional residency. If you do, most of the time USCIS will send you a letter saying they've terminated your status. However, that's not the end. As long as you have a reasonable explanation for why you filed late, you should still always file your 751 petition, because that's the way you're going to get your green card. Now, if you are filing, and when you file with your spouse, keep in mind the same evidence, the good faith bona fide evidence you used to get the initial conditional residency card is the same evidence you will still be required and you will still be questioned on. Example, if you use the divorce decree to get your conditional residence because you were married before and you have a divorce decree from terminating that marriage, and now you got married to your spouse, and USCIS approved your conditional residency request, if for whatever reason they have to verify your divorce decree again, they have the right to revoke your status if they believe that divorce decree was not genuine to start with. So all your records must match. You and your spouse must know each other, because you're going to be questioned as far as if your marriage, even though we said initially it was real, but yet again, you have the second interview within the next 2 years to be able to see if your marriage continues to be a real marriage. Not everybody's going to be interviewed for the 751. If you send in as much bona fide evidence of good faith marriage from the beginning, USCIS has the discretion to waive the requirement for the interview. If they do not believe your evidence for whatever reason, then they would have to schedule an interview. Now, if you are filing your 751 without your spouse, or you initially filed with your spouse, but prior to your interview, things have changed. You get a divorce, you've suffered abuse, something has changed that will now make it necessary that you will file that petition on your own. You have to inform USCIS. In my practice, what I do is I usually send a request to switch from a jointly filed petition to a waiver-based petition. Waiver grounds include divorce, death, extreme cruelty, and extreme hardship. Now, when it comes to divorce, death, extreme cruelty, those grounds for a waiver, you're still required to prove that your marriage was in good faith. Extreme hardship, on the other hand, there is no requirement to prove that your marriage was in good faith. However, that is the toughest ground to prove, because the good faith requirement is gone, and all you have to prove, or the whole burden on you falls on you being able to convince USCIS that if you are removed from the United States, you are going to suffer extreme hardship. Some of these factors they will consider include your age, how long you've been in the country, things that happen usually within the 2 years that you've been a conditional resident. Do you have custody of your child that's been here as an American citizen? Or did the conditions of your home country change? How will that affect you negatively should you be removed from the United States? Do you have a medical condition where if you're removed from here, you're almost going to be in danger of losing your life? Those are some of the factors that they will consider for hardship, extreme hardship ground. When you're filing a waiver of the joint requirement, because 751 waiver is just asking USCIS to waive the requirement to file jointly with your spouse. When you file a waiver-based 751, you do not have to wait for 2 years before filing. So, big difference. When you file jointly with your spouse, you are required to wait the 2 years. However, you can file within the 90-day before the second year anniversary. When you're filing by yourself, your self-petition 751, based on one of the waiver grounds, divorce, extreme cruelty, death, and extreme hardship, you do not have to wait for 2 years before filing. You can actually file your waiver-based petition within a week of becoming a conditional resident. You're not required to wait for 2 years if you are asking for one of those waiver grounds. Keep in mind that you would have the sole burden of being able to prove that your marriage is in good faith. Your marriage, and it resulted in divorce. You have a divorce decree. Your marriage was in good faith. You're not divorced, but you suffered extreme cruelty. Your marriage is in good faith, but unfortunately, your spouse has passed away, or you don't prove good faith, but you have to sustain the burden of proof in extreme hardship. So that is about all of 751 in a nutshell. Another thing that's important is this. Be sure to go on uscis.gov website. When you check the filing fee, when you check the edition date for the form, be sure to also check what USCIS office that you will be filing your 751 petition based on where you live. If you file with the wrong office, it will be rejected and they will send that back to you. Let's see, what else did I put here? Yes, I already said, if you're going to be switching, because sometimes, and I've seen that in my practice where I have a client who self-petitioned with a spouse, something happened, they got divorced, or they're not separated, and now they have to switch to a self-petition. And in that case, what I do is I don't like to wait till the day of the interview. I send a request that we're switching from joint filing to a waiver-based ground and support that with evidence to be able to back up why we're requesting that. So you can do that. It's always recommended to do that before the day of the interview. It doesn't hurt to also take all your paperwork to support why you're asking for a waiver when you have the interview. But if at all possible, do that before you have your interview that is being scheduled. So, and obviously when you get your 751, you're getting your 10-year green card. Let's see. I think that's about it. So, and another thing, oh yes, if you are filing with your spouse and you've been, and because of backlog now it's taking much longer. So we're seeing where 751s are pending and the petitioner is now eligible for citizenship. That actually helps to speed up your 751. Reason being, USCIS cannot adjudicate your naturalization application without first adjudicating your 751 petition. If you're not going to be granted a 10-year green card, there's no how they can grant you your naturalization application. But if you're going to be granted, then you will be eligible for citizenship. So if by the time you file your 751, you see that the time has passed and it's now 3 years, you're married to a citizen and you're filing jointly, or it's now 3 years, you're filing based on abuse, whether you're married to that citizen or not, as long as you're granted an extreme cruelty ground, a waiver ground, you will still be eligible to become a citizen upon the approval of your 751 petition. So that's a mouthful. That was a lot. Yes. So that's that in a nutshell. But be sure you get everything right. Do not guess. Your immigration journey is not a DIY project. I've said that so many times. It's always best get an immigration attorney. Immigration is beyond just filling forms. A lot of people that I represent, sometimes it gets too late to realize that. So the prudent thing to do would be to initially consult with an immigration attorney. Even if you don't retain one, at the very least have a consultation so that you will be informed and know exactly what it is that you have to do. If you need help with your cases, contact my office. Once again, that's my name. I'm scrolling on the at the bottom of the screen. Phone number here is 334-341-4475. If you haven't subscribed to YouTube channel, please do so. We're also on Instagram and TikTok. And please share this video. Please invite your friends to like our Facebook page. And thank you all for all the support. I really, really do appreciate that. You can also visit the website. Once again, that's olalayalawfirm.com if you need to set up a consultation with us. Consultation is $125 for half an hour. We have another option of $225 for 1 hour. If you retain my services within 30 days from your consultation, we credit that fee, the consultation fee, towards your total legal fees. And fees, I don't have set fees for each case. People always ask me that because everybody's case is different. So until next time, Facebook and YouTube, thanks for watching, everybody. Make sure nobody has any comment here. All right. See you guys next time. Bye-bye.